She said 1 minute.
Oh,
Okay, go.
okay. This is a regular meeting of the Ethics Commission of the Town of Chesapeake Beach. All members of the commission are present, as are our legal counsel and the clerk of the commission. So we're ready to proceed. And as usual, we start with the Pledge of Allegiance. Okay, agenda has been distributed, as well as the minutes of the last meeting. First agenda item is approval of the agenda. Okay, approved, and approval of the minutes of the previous meeting that was on January 13th. The minutes have been distributed. Are there comments, objections? It's approved. All right, now we get to the important stuff. We are reviewing the ordinance, and the work has started. You submitted something in writing, which has been incorporated. Because I was otherwise occupied by meeting many gentlemen wearing white lab coats and many very friendly young women wearing blue work clothes. And this is still continuing on day after tomorrow. I'll have a visit with my surgeon again. And then I have to browbeat him to doing some kind of magic that fixes the last shortcomings of my left leg. This would not go into the minutes. Okay. Also, among the materials that the clerk distributed, you find a very conceptual draft of the instructions for the filers of public disclosure statements. And it requires more work. I just wanted to put my piece of my work product into your hands so we can deal with it at the next meeting. Let me just explain what I hope to do. What you see there is in part new. I expanded the instructions on background explanations because we cannot assume that all the designated filers are familiar with the ethics ordinance, and so I try to expand this and give and provide a brief tutorial on what this thing is about and what people have to do and why. And it requires more work. The actual heart of the matter is the way it always was. There are two pieces of paper. One is what we call the list of schedules. The schedules are questionnaires that are designed to elicit the information that must be disclosed by law and by state mandate. And the second piece of paper, much thicker, are the various schedules themselves. Now they are attached to what you have, but my write-up says that these schedules will not be attached. I neglected to consider that the time for the next filings is rapidly approaching. That has to be done during the month of April. So we only have a little over a month to put this thing into final form. I also, in reviewing the ordinance, phrasing of the various questions in the instructions for the ordinance, for the closure statements, has to be put in sync with the commands of the ordinance. And over time, there have been slight deviations in the wording. So we'll have to do that. There are some other technical changes that have to be made. My keyboard, for example, doesn't have the paragraph symbol. You know, the two letters S, and so right now, old materials show that, newer materials do not. And I need some technical help to clean out these blemishes, because my machine can do it. Another thing is the cover sheet, which is the sworn statement that everything is true and complete. With my feeble keyboard skills, I was unable to put all this on one page where it should be. Right now it's on 2 pages, but I think it should be possible for somebody skilled in the art to condense portions of what appears on the first page, so that the 1 or 2 lines that I put on the second page, that all goes onto page number 1. So we have one piece of paper that I think is somewhat of interest to the person, Sharon, who has to physically administer all these papers. And we want to have, I would like to have as little paperwork as possible. The theory for the procedure, how to work, would be there are these 2 pieces that are distributed, or that I don't know how you would prefer to do that, Sharon. I think the last time around you made available paper forms for everybody, which most people didn't know. Most people used the online fillable form. And this is another thing which I don't know how to do. It was done by the previous town administrator, who is no longer with us. And Sharon will, have to say, how do we do this to do the final polish, so the paper that people see doesn't look amateurish. I also think that what people need to see as soon as they are appointed to offices that require them to file disclosure statements, they'll get the instructions and explanations, and two of the operating papers which have to be turned in. One is the cover sheet, which is the declaration of that everything is true and complete. And the second is the list of schedules. And I think that was your work product. I remember correctly. But it's the piece of paper where the responders are to indicate, does this question, this topic affect me or does it not? And there are very few filers who have more than 2 or 3 of these schedules to file. So I thought that in the normal course of events, which is starting next year, the actual schedules will be made available in some other way rather than putting everything on the in the hands of the filers, because most of these papers remain blank and get thrown out. And there are, I think, the easiest way to do that simply to put them on the town's website and have the people you turn in the list of schedules which you marked off. Does it apply or does it not apply? That goes to, they turn all that in to Sharon, and Sharon will give it to us. We'll look over it and see whether that is. And then when the time comes, the following month of March, of April, then each filer will pick the actual schedules that apply to that particular person. And I think we have 1 or 2 who live out of town, and they have no schedule to file because they don't own property in town or have a business interest, and so on and so forth. I think the easiest way is simply to put the whole thing on the website and say, you download those that apply to you, fill them out. I will also provide that they have to be signed, which I don't think we have not a present requirement. And only those 3 pieces of paper will be and that should eliminate a lot of paper handling. What we also have to work out if we want to have these things available online, we have to see whether what we have now is still workable, and whether the electronic version has to be upgraded. That's another thing that I cannot do.
Well, Peter, I have a question. This version,
Yeah.
Is the content changed in any way? Have you edited the content, or, I mean, the addition that you have up front, I think it's a great idea, the tutorial, if you will.
Yeah.
It's a great idea to separate that from that, because people who have done this before probably don't need that, but the new people need it. And but the rest of it, my question is that, has there been any substantial change?
No.
None.
No.
Okay, so if that is the case, this is the same as the
Previous.
statement of last year.
Yeah.
In the content, what
It's unchanged from last year. Right
last
now.
year, and I don't believe we have discussed about any changes. So as such, I would imagine the electronic version of this from last year is still should be usable.
It should be.
It should be. And as far as the other, the clerical formatting and so forth, I think we can trust that the town staff will be able to do what, suggestions we pass on to them. Right? So I guess the bottom line is that for this to go out on April 1st, the only thing that seemed to be needed is to just make sure if there's any formatting changes to be done to this. But beyond that, this is good to go in the paper form, and the electronic version should be good to go as
It'll
well.
be serviceable, yeah.
Just wanted to make sure that we are not talking about any actual changes that we need to review.
Once our revision of the ordinance is in place, then we'll have to go over the text of the various schedules and see whether we should adjust the language. But in order to amend the ordinance, first of all, we have to get it past the council. And secondly, it has to get approved by the state, by the legal department of the State Ethics Commission. And that also takes a little time, although they are very prompt in reacting to those requests.
Is it fair for us to assume that the update to the code will be finalized beyond the date of April 1st, and as such, it would, whatever changes that this will bring to the disclosure, which I don't believe, by the way, would be substantial, because I think most of the things we have talked about are outside the disclosure. The disclosure part, I think, is fairly untouched.
Yes,
If
yeah,
that is,
it's correct.
so as such, I think if we can uncouple these two and making sure that this is essentially good to go.
Yeah.
And then our work will be to continue working on this and finalizing it.
All right. One agenda point for next month would be to tutorial when. All right. Let's turn to the ordinance itself. Not quite sure how we go from the beginning. Oh, yeah.
You want me to walk through, because I made the changes, to just walk you through it?
Yeah.
Okay.
If you would.
Sure. Let's just, we just go in order. So the first set of changes are under 25-2 purposes.
Yeah.
And essentially, these changes were made to make the charter for the commission much more encompassing of all unethical issues or behaviors. And so you can see the changes primarily in item B and C under 25-2. Any questions, suggestions on that before we move on? And I think this is the part that we actually talked last time, to some extent,
Right, right.
in terms of, what does it mean when we say ethical? What should it include and should not? So to some extent, I think we have discussed these, and if you recall, we went through these, and then there were some comments that later on, Peter, you sent. And I think you made a few comments afterwards. And I think our focus, I would suggest in this meeting, is really focusing on those comments and see if they're captured properly.
Exactly.
Does that make
That makes
sense?
sense, yes. Agreed.
I think there's one thing that I would like to put on the table, a question, and I don't think we have gone into that research. I've been going over the definitions that we use, and I'm really not sure that we cannot eliminate some of them. There's no point in defining a term if it is not used in the actual ordinance. And as I said before, eventually we have to make sure that they all synchronize with the disclosure form that we hand out. But in a question. Just picking something at random, we define the term honorarium, and I don't think that appears anywhere else, anywhere in the ordinance. I then did not go through the whole thing, but just working from memory, and so.
So honorarium is defined in
It is defined.
right. Is it, you're saying that it's not used in the
It is not actually
disclosure
used.
at all? So it should be part of the gift,
If we
I would
just,
assume,
delete it.
Right.
right? Did we not include in the gift? So we can put that on the side or just address it now, because that goes back to if there are any updates to this, or should we just take this as is and remove that? Let's see, under gift, we had,
Including honorarium.
Well, and a related question that occurred to me is whether some of the terms that we define really require a definition at all. For example, we define employee as a person who is employed by the town, and wherever it appears, it is quite clear from the context that we are talking about town employees, but does not include an elected public official. Fine, but is that definition, is that term, does it need to be defined? An employee is somebody who is employed, which seems pretty obvious.
I think the delineation of the elected public officials are not employees may be of some value to people. that, okay, they're not actually employees, not
Well,
necessarily everybody knows.
yeah, yeah. I'm not disagreeing necessarily, but we talk about, for example, in the section that deals with disclosure statements, that has to be done by all elected officials, by certain appointed officials, and certain employees, and of course, employees of the town.
Logic.
Um,
I see your logic. So when it needs to, we have delineated the elected officials from employees.
Yeah.
So is that needed here?
Is it
I think that's a good point. Maybe
it
not.
It seemed to me that that term doesn't call for a definition, because where it is used in a context that makes it clear what we are talking about. If an operative sentence would be something like, the person subject to the disclosure requirements are all elected officials, certain identified appointed officials, and certain employees. And whether all the present filers, yes, all elected officials have to file, no question. And right now, the people who actually are filers, in fact, it didn't match up with the present wording of the ordinance. The ordinance requires that the heads of all town departments filers, but the town doesn't have departments.
Right, so we
They
have
all-
addressed that part. If I may interrupt, we have addressed that part in our revisions because we basically have taken that out of the code and we have said that it's going to be an appendix.
Yes.
And the town administrator, in conjunction with the town council, need to update that on a yearly basis.
Yeah.
Right. So I'm good with eliminating employee. Does that make sense? Is there any issue anybody sees? So done. So it's gone.
By the way, this particular item I would like to run by the mayor before we, submit a total revision to the because it's an operational matter, and I don't think we should spring it. I'm not concerned about the councilman, but the mayor.
And we talked about that. You're absolutely right. We talked about that too. That should be discussed with the mayor and the town administrator because it's something that needs to occur every year and they need to agree with that.
And we just invented work for you.
Right, right.
And we have to do it because the present ordinance doesn't mesh with the reality.
And it was defaulted to us,
Mhm.
the work. Okay, good. And then how about the other comment you made, honorarium? Again, if we are not using it, why define it? Makes sense to remove it? Okay. All right. Let's see if we bypass any of the comments. I'm sorry.
Are removing it, yes.
Oh, okay. And talked about again, I'm looking for comments that were added afterwards.
Oh,
Do we have any more comments on the definitions?
a comment, yes. We define entity to include a person, which obviously meant a natural person, a company, and so on. It sort of rubbed me the wrong way because I think the more common convention is use the term person to include a natural person as well as, an organization or a legal entity. At least that's from my feeble knowledge how the federal government does it.
Should it not include a person? Is that,
No, it should include, we can leave it that, I mean, technically there is nothing wrong with it. But if a reader reads entity, you will automatically think, yeah, it's a group, an organization of some kind.
Right.
It is not an individual. And in fact, I would even think it is easier from a drafting point of view to always write in the operative provisions a person or entity.
I agree.
And
Places do we use that here? I wonder.
entity is used at several places.
Like it says, if, for example, I'm looking at Schedule C, if a business entity
Yeah,
qualified as business, so in a way, it's consistent with the general
general understanding.
perception of the
Yeah.
term.
Also, this is something that I hadn't noticed after the first reading. Financial interest. We define it of an interest which entitles the holder to get more than $1,000 per year, and I still have it on my to-do list to check whether that conforms to the state mandate. We cannot introduce provisions that are more lenient than the state's mandates. Make tougher provisions, but we can't be more easygoing. And I just haven't gotten around to checking. The state has issued two model ordinances, and they necessarily reflect things that are right in the eyes of the State Ethics Commission. And what I have to dig out is whether they consider these model ordinances consider this $1,000 question. Because if they don't have a number, we can't say this because it would be lessening the lowering the standards.
Going back to the entity, should we remove a person from the definition of entity? How do we feel about that?
Yeah,
I would
say
read a company or a government.
Yeah, a company or a government or instrumentality of government.
Yeah.
And a company with a small c, I think would be generic, and it would embrace entity regardless of legal form.
Okay, so,
And
Agreed.
then wherever in the text we want to refer to a natural person, we will then
A person.
that's,
add
add that separately as entity.
person.
Right.
Yeah,
And in fact, if you read the one next to or right after entity, entity doing business with their town, it flows very nicely. I don't think any person as a person can do business unless they have a business or a company, right?
uh,
Okay, so I remove a person.
Person.
All right.
yeah. If of course the town can do business with a person.
Well, they have to have a business, right? You can't just do as a person.
Entity which has a, well, entity doing business with a town,
I mean, if we
the
want,
doing business with a town, then we have to expressly say an entity or a person which has a contract with a town, etc.
can a person have a contract without having a legal entity, an LLC, Inc., or
I
whatever?
think not. I think not.
Can they? Do you know, Sharon? Yeah, I'm not sure if you
I
really
think-
can. You have to have a legal standing. You can't be a person and doing,
Are there any
You
individuals on the
can be
list?
a professional.
Here's
Yeah.
the addendum showing everyone that's done business with the town. Are there any individuals on that list?
oh, that's a good point. Yeah. Yeah. Are there any?
I don't have it in front of me.
It can be a lawyer, for example.
Yeah.
I think,
The lawyer would represent a firm.
Not necessarily.
in effect, as far as I know, the legal counsel to the town, various bodies of the town, all organizations, but it could be a solo practitioner.
But would a practitioner not be protected by the legal setting of a firm because of liabilities and all that? It seems odd for me to take that. I would be very surprised if anybody, any person, individually would do business, and if the town would accept that.
So I myself have practiced as me, and during the time when I was not a member of a firm or an employee, not incorporated.
As an individual, you did and
As
got
an
compensated for the
Yeah,
work.
yeah. And so I was,
Okay, so if that's the case, we can add entity doing business with town and a person or an entity,
Yeah.
right? Which has a contract. Okay, so that takes care of that.
You need to make the same change on the next page under interest attributable. It says the following are deemed to be interests of a person covered by this chapter. I think it should be of a person or entity because it talks about entities.
where are
I'm
you
sorry,
now?
which paragraph is
Next
that?
page, it's under definitions of interest attributable.
Oh,
Only is deemed interest of a person or an entity is your suggestion.
Yes, because it talks about entities in that definition.
Okay,
or we can simply say the following businesses.
and the
Entity
the paragraph
that
2 under attribute interest attributable, paragraph B, the business entities is redundant, but I don't think it harms anything.
No, no. It's redundant though, yeah.
Exactly.
All these are business entities, if it, you cannot, in fact, nobody can have an interest in a business person, just an individual. Partner, business is no longer an individual.
So are we good with the rest of it? Other comments on definitions?
Good.
Yeah.
Okay, so moving on to Article 2. And going down to the comments. 5-9, we have some comments, relatively minor. Oh, there is Peter's comment. Okay, so
25.8.
that you added that last part, Peter. On 25-9, paragraph B, you wanted to add relating to this chapter. That's added. Moving on. Greg, you made some editorial changes down.
I love this section because we have to conduct a public information program regarding the purposes and application of this ordinance. We haven't done that, at least not during my tenure. Maybe my predecessor may have done it, but he is retired and in the wind.
So it's a good point. After we revise this, maybe we hold a public meeting or make it part of the.
Let's remember that this is ultimately derived on the state laws.
Right.
And state agencies no doubt have many more people who are covered by ethics rules and have to have disclosure requirements and so on. If it's, the State Department of Revenue, for example, a couple of thousand people there, probably several dozen of which, division department heads and so on, that they have to make public disclosures. And then it would make sense to say, next Thursday in conference room B, you have to show up for a lecture on certain things relating to the ordinance. I'm sort of reluctant to go to the town administrator and say, you have to tell this laundry list of people, about a dozen and a half,
Well,
that they have to get together here and listen to me and my colleagues to hold forth. We, if pressured, I would say, well, the package about the disclosure statement explains enough about the ethics ordinance so everybody understands what it is about.
So I agree with you up to the point that we hadn't revised the ordinance, but now that we are revising it and it's much more inclusive, it's not just disclosure, it's far beyond that, meaning that a resident can come to this commission and complain about something. So for that, I think having a public information session may make sense. And then town administrator could also invite the people who are who have to file disclosure to attend that as well. But that's not the primary objective. It's really review the new ordinance.
I fully agree. Just great slovenliness. That, haven't done any of this. There's the next one, E, submit a report on our activities at each meeting of the town council. We've never done this. And working assumption is that tacitly the council has waived this requirement. Although it's part of their regular routine to receive reports from certain officials, including the deputy sheriff who heads that little contingent that keeps us all safe. Engineer, usually there's something to report. I don't think had anything to report. But it has to be in there. We can't. I could do is talk to the mayor and say, do you really want to clutter up your council meetings with yet another report, which would probably, in most cases, we have nothing to report.
So that's one approach, to approach the mayor and ask about that. The other approach is that to revise that paragraph in the way we think is more appropriate, which I would propose that it may make sense that the commission would report activities that are worth reporting. I mean, if there's a regular disclosures that we went through and we had no problems, there's nothing to report. If there are cases where somebody or somebodies are not submitting them and they're dragging their feet, okay, maybe that's part of the report. If there is other issues that are brought to our attention and we need help to investigate it, that would be another scenario that we may need to go to the council. So make it more conditional rather than a blanket statement that we have to report. What do we feel about that approach instead?
Yeah, I think that makes it's good business sense.
The other option.
I will take a look at the model ordinances and look for the counterpart to that, whether it's in there.
Reflect, okay.
And if they do not, if their language mandates a report, whether or not there is something to report, then we cannot change this.
And then the discussion with the mayor would be in order to say that, do you agree that we are exempt unless?
Yeah, and that would cover our backside.
Right, right. So is that something you will take on and do after the meeting? And let us all know what they think? Okay,
I think another option to satisfy this is simply to submit the minutes from the meetings as the report, and to the extent that the council has any questions, they can ask for follow-up.
excellent idea.
Actually, yeah.
And that's routine then. And they're aware of what goes on if they're interested.
Mhm.
And we would really go to the council if there is something extraordinary that we need to get resources or what have you. Okay.
So I think that that language, that practice, if there is something to report, yeah, of course we do. We will.
Right, exactly.
So,
Okay, so, I mean, we have, I think that if the state language allows what our council is suggesting, I think that's a great way of,
Best way to do it, yeah.
right? Because the minutes are published every time. It takes the burden off of the chair.
That's right.
so I think that the town's government will probably always have the discretion to waive formalistically stupid. Nothing to report.
Mhm.
Report. I would also suggest adding a word or so to section E. Consult with the State Ethics Commission and others regarding possible improvements in the town's ethics program. You know, the way it's written, it reads that this is an ongoing obligation. And clearly it cannot be if we have nothing to suggest, then
I would just add after consult, just
if
put,
we say if the commission deems it necessary, or
yeah, and just say consult if necessary.
if necessary.
And
I'm sorry, which paragraph are you on?
E. 9E.
Do you want us to add that now, or do you want to send something, Peter? I can add, if it's a short thing, we can add. What
it
paragraph,
should be F also.
Oh, yeah, yeah.
what is
It
the,
should be F, not E.
At the
We have
end,
two E's.
if necessary, or if the commission deems it necessary.
what paragraph and what,
EE, it's the second E, which should be an F.
25-9.
25-9, E,
Letter
Two
E,
E's now.
yeah.
two
Second E.
E's.
It should be an F.
Consult with the state commission and other regarding possible improvements in the town's.
It shouldn't be E, it should be
Yeah.
F.
But, the formatting is all messed up,
Shouldn't be
so
identical.
let's not spend time on that. That needs to be really, hopefully we can find the original document so that those comments can be transferred there. Consult with the state commission as necessary at the end?
Right after consult. It's not.
Or at the end of the sentence?
Either way.
As necessary at the end. Does it read okay or preferred consult
That's fine,
as?
yeah. Yeah, it's fine.
Well, if I can go back to the definition one more time. Put defined terms always be capitalized or first capital letter throughout. The legal documents where that is, so it signals to the reader that this term is a technical term which has a defined meaning, may differ from commonly accepted dictionary meaning.
So that's a comment that, again, the final edit can incorporate. That's a fairly major.
Well, I mean, that would be the final beautification. The same run when we either take out the paragraph symbols and replace it by a section or paragraph in words. You look on the same page that we are on now. We have paragraph 25-8. The next one, no paragraph, 25-9. And it should either have that paragraph symbol.
So again, to just remind everyone, this document, we could not find the original Word document. So this was a converted document by Word from Adobe. And as such, it has many, many formatting
Many
issues.
errors, yeah.
Many.
Yeah.
The hope is that the actual original Word document can be located, can be found, and these comments are transferred there and incorporated in that document. Otherwise, if you spend time to look at the issues on this document, they're numerous.
Yeah.
Take forever too, yeah.
Has that document been located? Yeah, this is a major, I mean, regardless of, without that document, I think it's
it is somewhat important that we get that straightened out.
no question about it. And it's a major, otherwise there is a major proofreading for all of us to just make sure that the final thing that comes out, it makes sense. And I'm sure
Yeah.
it's going to have a lot of mistakes if we don't find the original document. So it is critical to find that document and then these comments to be incorporated in that. Whose file?
Previous, yeah. Could be, yeah.
It should be under, Holly took care of these things, right? She was editing them and all that. So it should be on the shared document. I'm surprised that not all the ordinances were left in one place, that these are the final version of the ordinance.
It must be somewhere because our other ordinances, they always have a, I have some.
So the ordinances in the Adobe version may be posted, and they are posted on the website, but those documents are generated from a Word document, and the Word document is the critical one to be found.
Yeah.
Is it possible that Fred would have them?
There must be a way, because just the most recent legislative enactments that I know of are provisions in the election law, which that shows, for example, the paragraph symbol, the interlocking
Right, right.
S's.
Yeah.
So somebody, whoever worked on it, I don't know whether Larry Getman did that or whether somebody in the office did it.
Right. Anyway, so that's beyond our.
But that's
thing. But
that's
a
in the
critical
future. That
piece.
would be the final
Yes.
beautification.
Well, I would call it more than beautification, frankly, because it's a lot of the typos and symbols and all those things.
Yeah.
And even regular words are misspelled, or as the conversion between Adobe and Word has happened. So it's right. Right. I hope that you can find it, Sharon, as I just pointed out. I think otherwise it would be a nightmare, a clerical nightmare. Okay, so where are we with, are there, what's the next comment? I can, moving down and just really focusing on comments. Either you had made, I wanted to,
Okay, I'm looking at Article 3, conflicts of interest. At 25-15, decisions in sole interest of town, decisions and other actions by covered people. And we don't have covered people, we have covered persons.
okay, let's take a look at this one. That's it is, okay, political contribution. Under the definitions, Peter, you made a comment. The reference to Maryland election law should
Let me-
perhaps be to the
Let me find it.
Peak Beach Campaign Finance Reporting Ordinance. This was enacted shortly before the recent election and contains the definition at the end of the election.
What section are you in?
But Sharon should. So you basically suggested that the political contribution refers to the town's campaign ordinance.
Yeah, until just a few weeks ago, the referencing to the state law would be appropriate. But since then, we have enacted our own campaign contribution law, and I think the reference should be to our own.
Okay, so that's, I guess, an action item for Sharon to look that up and make the reference. But other than that, I didn't see any other changes that required conversation. Of the floor to Peter. Either you have any other changes that you're
Well, I have a couple of things that I just put for my own benefit. Let me just raise one in conflict of interest. A covered person may not participate in any matter in which any of the following is a party. And the entities listed include entity that gets some kind of funding or requests funding from the town. And that would include, for example, the Northwest Fire Department, because they get money from the town. And, reading this, I said, well, does that generate a lot of conflicts of interest? Not familiar enough with the town's budget, but no doubt there's a line item there, standard contribution to the volunteer fire department. But well, does that lead to sort of conflicts that are really not problematic? I mean, if the council votes on that line item of contribution to the fire department, then none of them could participate in that decision, unless I misinterpret the ordinance. And surely we do want the town to keep the fire department solvent and the equipment repaired and their training up to date and all these things.
So what section would there be, you think that fire department would raise an issue?
It sort of went through my mind, and I'm not sure whether we should touch it at all, or carve out an exemption. There might be other civic organizations that get
And that'd be worth it.
Yeah, I would not be concerned.
And that may not be worth it to do that. Because there'll be other organizations as well.
yeah. Right.
Okay.
Somehow, I feel morally certain that this provision also appears in the state's model
I
ordinances.
would imagine.
If it's in there, it's not a problem.
Exactly.
So, let me just. Back in 25-38 enforcement, I think in my own copy here, the way it printed out is a little disorganized, but and I'm not sure. one of the remedies that the town can do, it's in paragraph letter E, 25-38 E, and number says impose a fine of up to $1,500. Now, the 1,500 is handwritten in my piece of paper here, but I don't remember what we discussed about.
So, okay, so we have made this version, we did change from $2 per day to $5 a day.
Yeah, I have that.
You have that.
Yeah.
And I think we did not finalize what should be the final up to, and I can't remember what is it in the current ordinance. What is the maximum?
Good question. 5,000.
Is it 500?
5,000.
5,000?
5,000?
Okay,
right
then
now.
in letter D, no, wait a minute, letter,
Yes, 5,000, yeah. Up to
Oh,
5,000.
wow.
letter D, decision by the commission may provide appropriate remedies. These may include assessing, number one, a late fee of $5 per day. And it says here, this is printed, not to exceed 1,500 in total. Does that still stand?
So where is the 5,000 then?
That's
The
down at the
original.
bottom. That's under E4.
So it didn't get captured in this translation, but, okay, so that 5,000, why is the number above 1,500?
They're two different, they're addressing two different things.
Two different scenarios, got you.
E4 is what a court is authorized to do.
I see.
The other one is what the commission can.
Commission can do, and I think 1,500 is significant enough. I think that the $2 was a problem because it doesn't accumulate much, really. I mean, a month is what, $60? So if it's $5 and now that's 150, that gets people's attention.
I think the fine has been before the council once before. I don't remember the exact circumstances, but nobody liked a higher limit. Everybody seems to love $2.
Well, okay, so I think when we present this to the council, we should point out that $2 is really insignificant, and really, when you think about it in the context of 1,500 being the maximum, that's 750 days to be late to reach that limit. So
Yeah.
that's like two and a half years,
2 years, yeah.
or 3 years,
Yeah.
you know. So it doesn't really make sense.
But are we in agreement that in E4, what the court can do is impose a fine of up to, and is that 5,000?
Right. Again, when we find that original document, hopefully that is there, and so that's part of the ordinance already.
And the late fees not to exceed the 1,500, 1,500 in total.
That would
Well,
be
that is-
300 days, basically, so almost a year.
It is if the daily fine for being late turning in a piece of paper, $5, it's more or less symbolic. Isn't it? Not even a slap on the wrist.
Well, I think if they're late, what, three months, That's not insignificant. That's $450. I don't think anybody likes to pay $450 for no.
Well, if the violation is so significant, then it causes, it calls for another remedy. That would be, and that person shouldn't be in his job.
Yeah, right. No, that's another thing. Yeah, and
And then one of the remedies is appropriate discipline, including censure or removal, if that discipline is authorized by law. Now, removal, I think, means getting fired from the job.
I think that's strong enough.
And yeah, and that, of course, has to be allowed by general employment law, whatever it may be. And you know, if there is, I don't think we have to explore that, but if there is a court decision somewhere in the state which says, you know, for turning in a report that you're obligated to give to your boss, and you don't do it, is the employer, is it lawful for the employer to sanction to fire you from the job? And for all I know, a judge somewhere or an appeals court even may have said yes, because turning in the report, doing your job, that's part of doing your job. And if you don't do it, you shouldn't have that job. And, some other judge may have ruled
Differently. Yeah, exactly.
But so, you know, we are, but, you know, for us, if it's authorized by law, it's sort of a savings clause.
And the
If
judge
it's
can
not,
take a look
then,
at it.
you know, we
decide.
cannot override state law. But
Can we talk about next steps before we talk about the next meeting?
Sure, sure.
So the next steps, in my mind, we have all the comments. The original document hopefully can be located. These changes can be then transferred to that. I would suggest, Sharon, that whoever does that takes these and put them as comments for us to review it one more time in our next meeting, and basically say that, all right, this as a whole, it ties together pretty well. And then make it final, and then we decide when to go to the council.
and at the next meeting, we must either do nothing about the disclosure statement and use the same format that we did last year, or if we want to, if we are impressed with my proposed improvements, then we will have to, you know, authorize that at the next.
I'm actually fine with what you have proposed. I don't think we necessarily need to revisit that anymore. The changes you have made make sense. It makes it more readable. So it's a matter of really getting that. And you said that the content is not changed, so the electronic version doesn't need to change. So I think we're in fairly good shape as far as for this year's disclosure. Does that make sense?
Yeah,
Yes.
I mean, we will not touch the operative document, which is the checklist, applies, doesn't apply, and the questionnaires themselves. So if making any changes there, that if we do it at all, it would be for another day.
That would be for the next cycle,
Next,
cycle.
2026.
And
So now it begs the question that, okay, when the document is revised and we get these changes, do we need to meet? Say we are okay, not okay, or capture some issues? I don't know.
Yeah, sure. If it's okay, I don't see the need to meet, really.
We received the document.
Electronically, yeah.
Each of us take our time, review it one more time.
I would say if I get any, I'll try and see the mayor about with the big operational change we make relates to, who is covered and who is not covered. And, and that is essential because the present wording of the ordinance doesn't matter reality. And it's primary obligation of this commission to take that to the council and say, hey, we have to do some house cleaning here. So I don't, and I think our solution is very elegant with a monthly,
Yearly.
rolling roster. And I cannot imagine that the mayor or the new administrator problem with it. But just in case they do see a problem, then you don't have to have a meeting.
Right, I think we can.
Because everything
we can
remains
compare,
as is.
exactly, right.
All right.
What is the next milestone? Disclosures are made available to
Next
filers.
milestone is a review of the disclosure statements. And that
And-
will come up
And they're supposed to be submitted by when? The end of April?
end of April.
I see. Okay, so sometime in May? And how long does it take to get everything collated? You need before we meet? Weeks, okay. That would be okay if you actually consolidate all of them and then send them to us. Or if you upload them somewhere, just give us the link. Either way. And do you go back and forth a little bit before you finalize? I mean, if you see something, you go back to them right away? Sometimes, yeah. I would imagine, yeah. So the week of 19th
The 19th.
sounds like that would be the time. The Monday is okay, like we are doing.
Yes.
Any member have something to announce to the public? Then in that case, we stand adjourned.
Thank you, Sharon.
This guy.